Keep winning. It's great. What happened to some
So as we're about to get started, but the students in the law and economics class should sit in the designated seats in front. Hello, everyone, and I want to welcome you. I'm Marcus Cole, I'm the Dean of Notre Dame Law School, for those of you who don't know me. I want to welcome our special guest today. But before that happens, I want to tell you a little bit about our law and economics program here at Notre Dame. This is a meeting of the Law and Economics seminar here, which is a year-long seminar, part of our Law and Economics program. That Law and Economics program also includes fellows as well as a postdoc. So it is a year-long program that encompasses all of those things. Now, to introduce our speaker today, I'm going to introduce my dear friend and our sometime colleague, the Prince. I have to have it on a sheet of paper because his title is so long that there's no way I could remember all of these words. It's I want to introduce the Principal Deputy Assistant Attorney General of the United States, Roger Alford, who will introduce our speaker.
Some of my Con students are here with me. Thank you for your patience. So Gail and I started talking in December about me joining her, and I thought, there's no way she's going to be in by the time my class is done. There's no way. So, because last time I did this in 2017, it was August. She's so uncontroversial that she got the most votes of any nominee for the Trump administration, other than Senator Rubio. By tradition, if a senator becomes part of administration, you have to vote unanimously. So he got 99-0. She got the second most votes of any member, 78 votes. And because of that, she got in early March. And I'm like, oh my gosh, I'm scrambling. How in the world do I finish my constitutional law class and join her as soon as possible, especially when the Google Remedies hearing starts April 21. I can't wait till May. So Sam Bray, to his great credit, was happily filled in for me to teach the rest of my Conlaw class. And the students are all telling me that they're loving it. It's so much better than when I was there, because he actually knows what he's talking about, right? So I'm just thrilled to be here. I'm on leave from Notre Dame to work with Gail Slater, and we've been talking for weeks about where should she give her first big address. And you can probably imagine she gets lots and lots of invitations every single week to speak different places. And she wanted to speak at Notre Dame because she thought this is the perfect place to talk about the conservative case for aggressive antitrust enforcement. And so I had a little bit to do with it, I think, with Gail's thinking, like, maybe Notre Dame would be a good place to go and come speak. And so she agreed to do that. She turned down Chicago. She turned down a bunch of other places. And I was like, of course you have to go to Notre Dame over Chicago. I mean, your first antitrust speech should be in a place that was founded by humble Catholic priests. Father Soren had $380 in his pocket when he started Notre Dame. Much better to speak at Notre Dame than at prominent universities such as Chicago, Stanford, Vanderbilt, Duke, or Carnegie Mellon, all universities founded by famous robber barons of the oil, railroad, tobacco, and steel trusts. Why would you want to speak at those universities as your first address in antitrust rather than speaking at Notre Dame? The other reason it's great for her to be here is because she's an Irish Catholic, like a real Irish Catholic. She was born in Ireland, and she moved to the United States after her degrees from Trinity College Dublin and Oxford University. She worked at Freshfields, and then moved to the United States, and then stayed here when she and her husband Lindsay were married. And so she's from Dalkey, and I like to joke she's the second most famous person from Dalkey, Ireland, other than Bono. So Bono is the most famous, and Gail Slater is the second most famous from Dalkey, Ireland. So she doesn't really need an introduction, but I'll just give you a very brief story about her. So she basically, I told you where she went for her education, but she worked at Freshfields, and then after that she worked for the Federal Trade Commission, for a Democratic commissioner for 10 years in the Federal Trade Commission, and then had a variety of other corporate positions with Fox Corporation, with Roku Corporation, for a technology trade association that represented small, medium, and large technology companies. And then after her time in the private sector and for working for those different trade associations, she, on a lark, decided to join Senator J.D. Vance's team when he was a junior senator from Ohio, which normally you wouldn't do at her stage in her career. She said, this sounds really, really interesting and fun. And so she joined him when he was a senator, junior senator from Ohio. And then Providence led her to then be on the vice presidential team, transition team, and then appointed as assistant attorney general. So she is just a wonderful colleague to work for. I have two great bosses in the room right now, right, with Marcus and with Gail, and they're equally great, but in different ways, exactly. And so I'm just really, really thrilled to have Gail here. The press has had this speech on embargo because they're desperate. We need the speech soon so we can write about it. They're on live stream watching this right now. But we're just thrilled to have Gail here. And please welcome Gail Slater. One other thing. Adam invited Jonathan Cantor here exactly a year ago. So this is like 2 for 2, right? We had the lead of the antitrust last year here, and now the lead of antitrust this year. So, great. Thanks very much.
Thanks, everyone. I'm just going to move this mic a little because I'm a low talker from Dublin, Ireland, and I want to make sure you can hear me. Not a professor from Notre Dame. Dean, I think we have to compare notes after. But he's great. He's great. I'm so lucky to have him. So I'm going to read from a script because, as Roger said, this is carefully vetted and will be carefully read. And I'll start by saying thank you for having me. It's an honor to be here at Notre Dame to give my first formal address as Assistant Attorney General for the Antitrust Division. As Roger said, I've had many offers to speak since I began my tenure at the Department of Justice, but it seemed appropriate that I present the conservative case for vigorous antitrust enforcement here at Notre Dame Law School. Notre Dame has a storied history in the development of American conservatism's first principles. I hold those principles dear, and as I will discuss, our enforcement of the antitrust laws will reflect those principles. Indeed, we seek to bring these shared principles to our work every day. They include American patriotism, textualism, and adherence to precedent, and a firm commitment to law enforcement. I also wanted to deliver an address here in Indiana because this state's economic history underscores the importance of those conservative first principles to the work I'm now honored to lead at the Antitrust Division. Indiana also played a role in molding Benjamin Harrison into the man that he would become. Although many may know Benjamin Harrison as the US president with the most impressive beard in American history, he was also the president who signed the Sherman Act into law in 1890. But more on that in a minute. Let's begin with some words of thanks. First, I am deeply grateful to President Trump for entrusting me with the responsibility to lead the Antitrust Division. When he nominated me, President Trump assailed the use of market power to crack down on the rights of so many Americans. I am so honored to have the chance to defend the American people's rights at this critical juncture in our history. I'm similarly grateful to the 78 senators from both sides of the aisle who voted to confirm me in an incredible show of broad bipartisan support for vigorous antitrust enforcement. And I'm also grateful to Attorney General Pam Bondi, Deputy Attorney General Todd Blanche, and all of the leadership of the department for their support. And, of course, last but not least, I'm grateful to my team of deputies, including my principal deputy, Roger Alford, who, of course, is here today. My earnest thanks also go to the men and women of the Antitrust Division. My first 2 months in the building have confirmed that the Antitrust Division employs some of the very best of the very best. Our cases consistently pit a small army of Davids against the Goliaths of both big law defending big business. Yet, as we showed in the recent Google ad tech case, our teams more often than not win the battle on behalf of the American people. The stakes of that fight are so high. The American people are once again facing a generation of economic and industrial change. We are adapting trade policies to put America first and undertaking deregulation that will unleash innovation in AI and other technologies and will reshape our economy. But we face a choice in who will order this realignment and how. Will the American people shape tomorrow's economy, or will others decide what gets made, where it is made, and who makes it? Will our laws be written by Congress and enforced by politically accountable appointees in the Trump administration, or by technocrats and lobbyists elsewhere? Indiana has seen firsthand the consequences of getting these choices wrong for millions of Americans. If recent decades have shown us anything, it is that we need an economy that works for the American people and not the other way around. We also need public policies that afford our fellow countrymen and women the dignity they deserve as American citizens. Of course, antitrust is not a cure-all, but it can surely play an important role in building a more resilient economy going forward. To better understand what this future might look like, we first need to look to the past. As I like to say, the past is prologue. We all know the story of the decline in manufacturing in this state. Indiana was at the heart of the United States' thriving manufacturing industry for much of the 20th century. But then, in the 1960s and 70s, the factories started shutting down. The Studebaker factory closed here in South Bend in 1963, and other Indiana cities experienced similar population declines as manufacturing moved overseas. It took decades for cities such as South Bend to recover, and some have still not recovered. Of course, change is inevitable in a dynamic and innovative economy such as ours. Economists call this creative destruction and shrug it off as mere market forces at play. But neoliberal public policy also played a role in enabling this creative destruction, and not always for the better. Policy makers in Washington, D.C. voted for free trade agreements that ship jobs overseas. They opened up our southern border to mass migration, and they under-enforced our century-old antitrust laws. In D.C., these neoliberal policies are collectively referred to as the Washington Consensus, and they were the foundation of our economic policy for several decades. They were born out of the optimism that followed the end of the Cold War, sometimes referred to as the end of history. They promoted globalization and the financialization of the US economy, and they initially spurred economic growth and prosperity. But that growth left many Americans behind, which brings us to today. Some say that free trade and open borders result in a larger pie, but this begs the question as to the size of the slice that each community in our society received. At the same time that global labor arbitrage traded American jobs for cheap manufacturing abroad, growing profit margins diverted the economic gains for many goods from American consumers and workers to our coastal elites. Too many communities hollowed out here in Indiana and across the nation. This hollowing out in turn created the conditions for a weakened middle class, fractured families, and, in some cases, deaths of despair. What was good for a few powerful corporations, it turned out, was often bad for dynamic businesses and innovators that made us the greatest nation on earth. It was also bad for the communities in which those businesses once thrived. Our Treasury Secretary, Scott Bessent, recently said something incredibly important about all of this. Access to cheap goods, he said, is not the essence of the American dream. The American dream is not let them eat flat screens. Instead, he said, and I agree with this, that the American dream is rooted in the concept that a citizen can achieve prosperity, upward mobility, and economic security. Antitrust law enforcement plays an indispensable role in achieving the American dream because competitive markets enable individuals to achieve this prosperity, this upward mobility, and this economic security. That's the premise of free market capitalism. In free markets, the American people shape the economy toward their own flourishing by starting and growing their businesses, and through their choices in markets as buyers and sellers. Competitive markets enable the American people to build the lives they want, not just as consumers and producers, but also as citizens. That's the main thing I want you to take away from my remarks today. People ask me what my agenda will be pretty much every day. I get asked this question all the time. How does antitrust fit in with the realignment underway in the Republican Party? I tell them it's America First antitrust. America First antitrust empowers America's forgotten men and women to shape their own economic destinies in a free market. We will stand for America's forgotten consumers, we will stand for America's forgotten workers, and we will stand for the small businesses and innovators, from little tech to manufacturing to family farms, that were forgotten by our economic policies for too long. So how will we accomplish this, and what are our guiding principles? I submit we need only look to the past and to our conservative roots to find these principles. America First antitrust roots are grounded in the Sherman Antitrust Act, but they in fact date back to our nation's founding. Let us not forget that the Boston Tea Party was a protest not only against the British government's taxation without representation, but also against the monopoly granted to the British East India Company. The Granger movement at the end of the 19th century planted the early seeds for antitrust enforcement. It was born and raised by conservative hillbillies in the heartland in defense of their fundamental values. Finally, America First antitrust continues the legacy of Ohio Republican Senator John Sherman, the namesake of the Sherman Act. A true economic populist who never went to college, was a self-taught engineer, and became a lawyer under the apprenticeship of his brother. With the remainder of my time today, I'd like to talk about the conservative values that I see underpinning America First antitrust. This speech is not intended to be an LLM thesis, although it is pretty long. So I'll address three that matter most immediately to the work at the Antitrust Division. The first is the protection of individual liberty from both government and corporate tyranny. Second, a healthy respect for textualism, originalism, and precedent grounded in a commitment to robust and fair law enforcement. And third, a healthy fear of regulation that saps economic opportunity by stifling rather than promoting competition. I'll address each in turn. I have to begin with the value that defines both conservatism and America, and of course, that is to say, freedom. We are a nation born from opposition to tyranny in defense of individual liberty. As a new American, I cherish the freedom that comes from being an American citizen. As I testified at my Senate confirmation hearing earlier this year, in our constitutional republic, American citizens can speak their minds, earn a living, and invent new technologies free from unwarranted interference. These freedoms are not guaranteed in so many countries around the world, so they must be cherished and defended by us all. How does this bedrock American value translate into antitrust? Let me explain. Here at Notre Dame, the principle of individual moral agency is second nature to you all. And though few are Catholic themselves, the founding fathers believed philosopher Thomas Aquinas when he argued that humans are imago Dei, beings made in the image of God, whose exercise of individual moral agency defines us. We realize our goodness and define our own flourishing through our freedom of choice. And so the founders penned the Declaration of Independence, reaffirming that it is self-evident that humans are endowed by their Creator with the rights to life, liberty, and the pursuit of happiness. With that, they threw off the tyranny of King George. In so doing, they rejected his grants of monopolies in the colonies as inconsistent with their natural rights. Incidentally, that same year of 1776, the Scottish philosopher Adam Smith published his seminal book on economics, The Wealth of Nations, in which he wrote, "People of the same trade seldom meet together, even for merriment and diversion, but the conversation ends in a conspiracy against the public, or in some contrivance to raise prices." Ill-gotten monopolies inherently restrain human liberty by depriving individuals of choices as both consumers and producers. That is why popular opposition to the East India Company monopoly led directly to the Boston Tea Party and played an important motivating role in the founding. Of course, monopolies at that point in our history required the grant of a king protected by his law. With the success of the revolution, they largely disappeared from American life for a time. As a result, innovation flourished over the ensuing century, and many new inventions, from the cotton gin to the light bulb and the telephone, launched technological revolutions that improved the lives of all Americans. But the 19th century also saw the emergence of a new kind of monopoly, a private empire of oil, railroad, and agricultural robber barons, who, according to Roger, used their fortunes to found some of our greatest universities. These private monopolies threatened liberty, just as King George once had himself. Although the identity of the tyrant changed, the threat posed by monopoly to the American people's endowed natural rights to liberty had not. The Grangers were among the first to point this out. In the 1860s, Midwestern farmers, known as the Grangers, began to unite against railroad and grain elevator monopolies that deprived farmers of fair competitive returns for their crops. In 1873, the Grangers echoed our founding principles in their Farmers' Declaration of Independence. The history of the present railway monopoly, the Grangers declared, is a history of repeated injuries and oppressions, all having in direct object the establishment of an absolute tyranny over the people of these states, unequaled in any monarchy of the old world. And so they called for government action to constrain this private tyranny. This was the perspective that in 1890 drove an Ohio Republican from the foothills of the Appalachians to draft the nation's first federal antitrust law constraining private monopolization. Senator Sherman saw his bill as an extension of the founders' rejection of the tyranny of monopoly in defense of liberty. "If we will not endure a king as a political power," Sherman said, "we should not endure a king over the production, transportation, and sale of the necessaries of life." To ensure care and precision in using government power against private monopolies, the Sherman Act preserves liberty by promoting economic competition that benefits consumers, workers, inventors, and other trading partners in free markets. We are now in the midst of another fundamental change in the nature of monopoly. While the Grangers and Senator Sherman saw the first emergence of privately organized monopolies, we are experiencing the emergence of new, durable forms of monopoly power altogether, the likes of which the Grangers and Senator Sherman could not even begin to fathom. These monopolies are driving a Republican realignment away from big business and, under President Trump's leadership, towards the working class that is reconnecting the party with its roots, recognizing antitrust as a critical tool in protecting individual liberty. In Senator Sherman's day, a monopoly could control prices and exclude competition. Today's online platforms can do so much more. They control not just the prices of their services, but the flow of our nation's commerce and communications. These platforms play a critical role in our digital public square. They are key not only to the ordinary citizen's free expression, but also to how elections are won or lost, and how our news is disseminated or not. This point is being made again and again by members of the New Right, who are driving the realignment in antitrust policy. Sohrab Ahmari points out that just as conservatives fear tyranny.gov, they should also fear tyranny.com. Oren Cass underscores how conservatism is hugely skeptical of power. Senate Antitrust Subcommittee Chair Mike Lee has explained that concentrated economic power can be just as dangerous as concentrated political power. And other influential senators like Josh Hawley and Chuck Grassley similarly support robust antitrust enforcement aimed at tackling unchecked market power. Vice President Vance has been similarly outspoken. He has decried the weird idea that something can be tyrannical if it comes through the operation of a free market. Sorry, I should say can't be tyrannical. Amidst an environment where companies control the flow of information in our society. I echoed this growing sentiment on the right at my confirmation hearing earlier this year when I testified that we have grown to appreciate that personal liberty and economic liberty are closely connected, that in many ways they are two sides of the same coin. And Americans have also come to see that economic liberty often hinges on competitive markets. So that's the first principle of America First Antitrust, which is to say antitrust enforcement serves the deep-rooted conservative goal of protecting individual liberty from the tyranny, of course, of monopoly power. And it serves those goals where it matters most, to protect our liberty online and to ensure that we protect Americans on pocketbook issues such as housing, healthcare, groceries, transportation, insurance, entertainment, and the list goes on. The next core conservative value underpinning our antitrust enforcement begins with the important acknowledgement that government itself can be a coercive force that threatens our liberty. This is the so-called tyranny.gov I just talked about. Conservatives have long been skeptical of government regulation that deprives businesses of their economic freedom and makes our economy less dynamic and prosperous. We must respect originalism and the rule of law and ensure that our enforcement derives from the will of the democratically elected Congress as interpreted by the courts. A truly conservative approach to antitrust law starts with first principles and text, but you don't need me to tell you that. This means that antitrust agencies should enforce the laws passed by Congress, not the laws they wish Congress had passed. Perhaps most importantly, antitrust in the United States is law enforcement. It is not regulation. Congress enacted the antitrust laws as a legal regime, declined to provide any authority to regulate the details of the Sherman or Clayton Acts, and instead gave the Attorney General the duty to pursue cases before the courts as she does any other action. To recognize federal antitrust law as law enforcement in the American tradition requires a strong commitment to our constitutional separation of powers, including executive enforcement prerogative, statutory meaning, and judicial precedent. A faithful humility to law's limits is the cornerstone of much conservative legal theory. If we are true to our principles, antitrust cannot be an exception to this general rule. In the play A Man for All Seasons, St. Thomas More discusses an England planted thick with the common law and says he would give the devil benefit of law before accepting the lawless reality of a society without them. The English common law tradition of St. Thomas More has more to do with federal antitrust enforcement than many may at first realize. Senator Sherman designed the Sherman Act to incorporate the common law in the American states and England on restraints of trade and monopoly. That is why the Act included specific terms of art from the common law, including restraint of trade and monopolize, whose original public meaning must be understood with respect to the common law that they emerged from. In so doing, the Sherman Act included prohibitions on price fixing and concerns with restraints of trade harming both workers and end consumers, among many other foundational principles of the common law. The antitrust laws must be interpreted in light of their purpose and context to include the common law and state antitrust laws. Respecting the rule of law critically requires giving meaning to the statutory text and applying the binding precedents interpreting it, both old and new. Innovations in economic theory and practice may shape more recent law, but they do not render older precedent a dead letter. That is the Supreme Court's prerogative. This observation applies in particular to our merger enforcement work at the DOJ. As we move forward with merger enforcement, there will be important debates about the weight we should place on older versus newer precedent as we make decisions. Those are important debates to have, and I have an open mind, as does Roger. But at the end of those discussions, our enforcement will apply our prosecutorial discretion based on the best interpretations of the laws on the books and analysis of economic facts and data, respecting the original public meaning of the statutory text and the binding nature of Supreme Court and other relevant precedent. This is a deeply conservative position, and there is nothing radical about it. To the contrary, what is radical is the notion that we should, as antitrust enforcers, ignore the text of the law and divorce ourselves from binding precedent, both old and new alike. Respecting the statutory text also helps us defend ordinary Americans who need competition for their work to raise wages and improve working conditions. When Congress prohibited restraints of trade, the term was understood to include restraints of working a trade, as Justice Story explained in his commentaries on the common law. Or as Justice Kavanaugh recently said in Alston, price-fixing labor is price-fixing labor. Our recent Las Vegas nursing case is a great example here. A jury convicted a Nevada man of a 3-year conspiracy to fix the wages of home healthcare nurses by capping their wages. Hundreds of hardworking nurses were affected, and they deserved better. Nursing work is not only important and difficult, it is also the backbone of our middle-class communities. I am so proud of our team for standing up to those nurses. This is what America First Antitrust is all about in essence. The last conservative value I'd like to talk about today is a preference for litigation over regulation. Conservatives abhor anti-competitive government regulations that unnecessarily sap the free market of dynamism. Aggressive antitrust enforcement supports a competitive process that enables markets to regulate themselves, providing a bulwark against market power that often leads to regulatory intervention. In recent decades, we have seen markets tilt towards regulation as they have become more concentrated. The poster child here is the regulatory intervention that followed the 2008 financial collapse. Of course, you all were mostly kids in 2008 when the financial collapse wreaked havoc on this economy. But those of us living in DC saw financial institutions that were considered too big to fail rapidly succumb to new regulation in the wake of it. For many, an important question that arose at that time was less about the merits or demerits of the regulations that followed in the wake of 2008, and more about how those financial institutions became too big to fail in the first place. Relatedly, many questioned whether these regulations could have been avoided had these markets not become so highly concentrated. Finally, they questioned the role antitrust played in allowing this state of affairs to exist. This view was at the heart of the enforcement philosophy of one of my most distinguished predecessors as AAG for antitrust, Robert Jackson, who earned public acclaim as the lead Nuremberg prosecutor after World War II, and later on as Supreme Court Associate Justice. In a 1937 speech, then AAG Jackson noted, and I quote, "The antitrust laws represent an effort to avoid detailed government regulation of business by keeping competition in control of prices. Through the antitrust laws," he said, "it was hoped that the government would confine its responsibility to seeing that a true competitive economy functions." As Robert Jackson noted then, enforcement of the antitrust laws is the lowest degree of government control that business can expect. This is a limited role I'm happy to take on and defend today. As I've analogized, antitrust is a scalpel and regulation is a sledgehammer. Free markets often fail, and one cannot wish away monopolies and cartels with false economic theories of self-correction. The scalpel is necessary to make targeted, incisive cuts to remove the cancer of collusion and monopoly abuse. That is America First conservatives' preferred approach to cure market ills. It imposes government obligations only on parties that violate the law, and only for the limited time necessary to restore competition. In contrast to this, ex-ante regulations cover all parties in an industry for a long time, permanently distorting the free market rather than merely curing diseases that were destroying the market in the first place. Worse still, a system of anti-competitive regulation can be co-opted by monopolies and their lobbyists, such that the state's power actually amplifies rather than diminishes corporate power, and leads to the proliferation of government regulations that serve corporate interests rather than those of the people. Scholars like George Stigler have explored regulatory capture and how an industry can use the state for its purposes, seeking regulations that operate primarily for the industry's benefit, for example, to control entry or insulate prices. Corporate lobbyists using their power to undermine free markets are ubiquitous in our system, in particular in DC. And small but powerful groups can dominate regulatory processes at the expense of the diffuse interests of individual citizens. This alliance of big business and big government should be broken. To combat against such laws and regulations that stifle rather than promote competition, we have launched the Anti-Competitive Regulations Task Force. Consistent with the Trump administration's deregulatory efforts, the Antitrust Division's task force will seek to identify and eliminate laws and regulations that undermine the operation of the free market and harm consumers, workers, and businesses. We look forward to working with the FTC and with partner agencies throughout the government on these efforts. So in conclusion, let me finish where I started, with an appreciation for the economic conditions here in the Midwest and a healthy dose of humility at the challenges we face, recentering the American people in the functioning of our economy. America First Antitrust cares deeply about the average American in the heartland, and our efforts will focus on those markets that most directly affect their lives. We are here to serve all Americans and wish to move away from the technocratic and elitist mindset that has imbued antitrust law enforcement for several decades. I humbly submit that if a farmer in Indiana or Iowa cannot make sense of our work, in particular my work, the fault lies with us, not the farmer. I may not be invited to cocktail parties in Georgetown or speaking engagements at Stanford or Cornell Law School following my remarks here today, but I will gladly trade this for coffee with Senator Grassley at a Cracker Barrel or his own beloved Dairy Queen whenever he can fit me into his busy schedule, if he's listening. We will not restore the vitality of our long-forgotten communities overnight. It will take complementary work across many domains, from trade to antitrust to deregulatory policy and so many others. But with President Trump's clear commitment to fight in all those areas for this country's forgotten people, and with deep-rooted conservative principles to guide us, I believe we can build a truly great future for our children. And I look forward to that work. Thank you all so much for listening.
Are we okay with questions?
Yeah, of course.
So we have lots and lots of students in the room. We have antitrust scholars in the room. We have constitutional scholars as well. So why don't we just open the floor up for questions, and maybe I can start with some of this.